There are four main types of intellectual property rights: patents, trademarks, design and copyright. Copyright and unregistered design right are automatically available, provided the item of property is original. The others need to be registered in order to obtain protection. Very briefly, a patent is your invention, the trademark is the brand, the design is the appearance, and the copyright is the content. A trademark is a brand. So most businesses have a brand. It's what puts a value to the goodwill that they might generate in the business. Nowadays, with online businesses, the trademark might be the only asset that a business has. And in fact, a high percentage of FTSE 100 companies now have intangible assets listed quite highly on their balance sheets. And there's no reason why that shouldn't also be the case for small businesses. There are two main reasons for getting a trademark protected. You can trade without getting it protected, but if you do so, you don't have registered protection for your asset and you run the risk of running into conflict with third parties. So in terms of an asset, if you protect it as a registered trademark, it is a piece of property belonging to your business that can go on the balance sheet. It can also then be sold or licensed or franchised to anybody else that you choose to, and you have control over that and your rights are recognised. In terms of not conflicting with anybody else, there's no point in investing in a brand new company if when you launch you're in conflict with somebody else, or your good work or your hard work is undone. As a result, the expense is variable. It depends on the number of classes, i.e. the number of goods and services that you provide. That determines the cost. As a very rough idea, £1,000 will cover you for a fairly straightforward application in a number of classes. Although that isn't an insignificant sum for a small business, compared to having to rebrand with stationery, new website, that kind of thing, it's not a massive amount of money. A business should protect the website and the domain name. If your most obvious domain name isn't available, that's a fairly clear sign that somebody is already out there competing with you. So you need to refocus and find something else, otherwise you'll spend a lot of money fighting that other company before you even start. I would, however, recommend that you don't register more than a couple of domain names because they don't grant you any rights. What you need to do is get the trademark that is covered by the domain name, so the brand that you are registering as a domain name. Once you get that protected, that stops anybody else from copying what you are doing. If you create a new brand or logo or anything that has required creative input, you should protect it. It gives you protection for your input in terms of time and effort. It also makes sure that you can prevent anyone else from copying you after you launch, and to make sure that you're not infringing somebody else. In order to obtain protection, the best way to do it is to contact a firm of patent and trademark attorneys. Copyright protection is available for the content of something that you create. It might be a literary or musical or artistic work, and it can be many other things. It's available provided that the work that you have created is original. In order to prove your ownership, you need to docket when you created the piece of the work. And that can be done. Often people will send it in a sealed envelope to themselves. That's really just making sure it has a date on it, but it can be done electronically or various other means. Copyright can be very expensive to enforce because it's not a registrable right, so you have to prove your ownership before you can enforce it, and all proceedings are done through the court. However, if you find out about copyright infringement going on, often a letter from a firm of patent and trademark attorneys warning the other side that infringement has occurred can be sufficient to stop the infringement occurring any longer. Trademarks, IP and copyright, and patents and designs are a tricky subject. Most companies don't come across them, unfortunately, until they encounter problems. This can be because they're parting ways with somebody they've been in partnership with and don't know who owns what assets, or it can be because unwittingly they have infringed somebody else's rights. Also, it's a common misconception that domain names and company name registrations will give you protection, and they won't. The only way to get protection for your branding is through your trademark, for your invention is your patent, and for the content and the appearance is through copyright and design.